Hello, hello, hello. This is Attorney Mike Griffin coming to you from Chicago. As usual, we have all sorts of crazy stuff. I've got great clips coming up. I've got good stuff from the usual suspects. Brecken, Zach, Lab Matt, MGT probably did something too. I don't know. We got all sorts of good stuff, but I've spent a lot of time with SovCit Vaughn. Let's give Mr. Vaughn a SovCit salute. He's really beclowned himself several times in the last few days, and we've had a lot of fun with it. First, he had a motion hearing, which was an epic failure, where among other things, he had a motion to squash. then he then he went on to the actual jury trial. Oh, also in the motion to squash, he mentioned that he was not Mirandaized. And then we went on to the jury trial where he was an epic failure. And then we had post-trial motions, all of which are good. So I grabbed a couple clips. So in the last one, in the post-trial motions, I said, okay, I need some songs for this guy. Actually, I would think it's Maria's fault. But it was a good idea. Zach and Killer Hippo, get them to me. I think during the stream, they're that fast. But I didn't have it put together. So I had to do a little remix. I had to do a little Dr. Seuss salute to Sovereign Citizen Vaughn. Wait, should we warm? I think we should warm it up with one of them. Let's warm it up with Zach's hit, which I tried to play but couldn't. Let me find it here. It's called Moat Point. Moat Point Madness. Let's do it.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. Words all twisted. Sheriff Vaughn speaking like logic got evicted. Mirandaization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He realliterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a
what did we just heard is inspired. It's inspired.
Point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like his courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick, but he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose, but every fake word just adds to your blues. Mirandaize this, moat point that. Sheriff Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Mirandaization, unlogical station. Courtroom clown in rotation.
All right, here's some highlights of this. Here's some highlights, but let me tell you, it's certainly not limited to just this. It's certainly not limited to just this. There's a lot more that comes up in the songs and other stuff. It's just what I could grab. It's
Days
short.
Rested and you had failed, but I'll allow her to come back to the stand for you to ask one more question.
At any time, did you Mirandaize me?
I'm sorry, repeat that.
At any time, was I Mirandaized?
Were you what?
Mirandaized. Did you read me my
Mirandaized.
Miranda rights?
Not that I recall.
Not that you recall. Is that normal procedure too? When you're going to arrest someone to read their Mirandaization?
Not every time, no, sir.
Not every time. With this situation, would you say cause for it? This arrest, pertaining to this arrest.
That made my night.
Make motion to exclude regarding statements pursuant to Tennessee's rules of evidence 403 probative value substantially outweighs the prejudice.
Probative.
And I was in custody with no ability to carry out the threats. The statements was not made specifically at Jarvin's, who was having victims, and he didn't witness me state anybody's name. He just made an assumption that it was for all in law enforcement. There's no relevance to
all the law enforcement.
So are you objecting to relevance, or are you objecting under the rule that exclude, I'm assuming you're...
Oh, yes, sir. I've had previous motions asking for the paperwork filed into this case previously. They have been unheard. They have not been served or answered or any response to it. So now I'm requesting compellment.
Compellment. Oh, my God. Oh, I thought we achieved Max Stupid already. I thought we did with Mirandaization, but no, now we've got compellment. We've got compellment. I don't know where to begin here. I don't know where to begin. The problem with these guys, he very much reminds me of Brooks and a lot of the other ones, Magoo and everything, but they're literally, what shields them is that they are so stupid. They don't have the sense to be ashamed. There's nothing. That's what makes it so delicious, though, because then they just keep going. They keep talking and providing more entertainment.
Right. Grab a White Claw. Settle in today. We got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of filings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandaization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruits. The fruit, the tainted fruits. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin so calm. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with a glare, then a scholar on cross-exam says hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video. It's misunderstood. Oh geez, here we go. He's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body can rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice.
Both just bangers. Bangers. Serving up as Tainted fruits. Ah.
Come online with a screen named Samsung SM.
Yeah, Sharita.
Okay, I'm to the point now where I actually have enough for Songs in the Key of Stupid Volume 2. But I got to figure out how to put video behind it. I've got the songs already because everybody sent them to me. But I got to figure out how to make that video. For those of you who don't know, there's Songs in the Key of Stupid Part 1. And it's fantastic.
Folks.
This is citation 25P 1997-13. It's an overtime parking ticket that was issued on July 31st of this year. The allegation specifically is that you were parked on Center Street in space 601 for 1 hour, 8 minutes, and 13 seconds, and that you didn't pay anything.
I did pay. Yes, I did. I paid $3, and it said 602 parking spot. It had 603 to the left and 602 to the right. It was me and my sister. I paid with my credit card. I have it on my credit card statement that I paid $3 at 6:40
The car was
p.m.
in with 601.
The arrow it was pointing at said 602, so that's why I put in 602 for the space.
I thought you said it was 601 to 603.
Where it said to, like I said, to
I don't know how to do that, and they're not mine.
the left it said 603, and to the
I did not make one of these songs. I got probably 15 of them. I did not do one of them myself.
right it said 602. So I put 602 and paid $3.
Are you driving your car now? Man, this is crazy. You can't be driving a car and be on Zoom. Well, you're going to get killed or kill somebody. We're done. This hearing's over.
This thing's over.
We'll reset this.
Chisnator's not putting up with this crap. No, this hearing's over immediately.
I was looking at the data on the. Can you imagine watching a crash from the inside of somebody else's car?
No.
How would it feel to see a crash from inside somebody else's car?
That's scary.
Mr. Peoples? Hey, how are you? How you doing up there? Okay, we've got all these cases which we need to move forward on, right? And
Yeah, it's good to be me.
the state is here. I've got this aggravated sexual assault in 193629. I've got.
That's the case the state intends to try first, Judge. So,
Let's put that.
we've already tried.
Yeah, I got
tried
193362A, aggravated sexual assault.
that one will probably go away once we try 29.
I've got this 23 CR 727, aggravated assault against public
Yes,
servant.
sir. That'll be the next one we try after the aggravated sexual assault.
And I've got 23 CR 1110, implements for escape in a correctional facility.
Yes, sir. We'll probably try that last.
193368, that is one that the state doesn't feel real strong about.
That's correct, Your Honor.
All right.
So we're mainly going to try those three.
So what we do have is 19-33629, the first degree felony. And this is aggravated assault on a public servant. Correct?
Yes, sir.
No, that can't.
No, there's 33629 is the aggravated sexual assault.
This is the wrong file. Goes in the line. This one we've already tried before, right?
Yes, sir. It was a hung jury.
That's thank you.
It was 9-3 for guilty. We're going to try it again.
Okay. Mr. Peoples, you represented yourself on that, right?
Yes, sir.
Yeah.
Is that what you want to continue to do, sir?
Most definitely.
Okay, all right. I think we went over all those things, but the difficulties of representing yourself, but you understood it, made representations. That's what you thought about. You thought about it, and that's what you intend to do. If at
Maybe Vaughn can help him.
any time you change your mind, let me know, okay? And we'll have somebody come in to assist you.
He doesn't have a law license, but he does have poetic license, and he can just make up words, and everyone's expected to understand,
At any time you decide.
which is nice.
Otherwise, did we have somebody sitting next to him in the event he changed his mind needed to get some advice during the trial?
Do we have the lawyer sitting with you?
No. Do you want one?
Not at all, but I do want to move the court to dismiss these charges
Okay.
based on the tampering with evidence, the fact that y'all destroyed my primary evidence.
Who did that?
I don't know.
Did I do that?
My phone, the primary evidence that I stated in my 1107 habeas
Yes, there
corpus,
is.
my 2254 habeas corpus.
Yeah, was what? The phone?
Yes.
Which phone is that?
The phone that y'all destroyed.
Who? I didn't destroy a phone. What does it? I don't touch things like that.
Well, because
Was that
the people
evidence that the
Yes.
police had recovered?
yes,
They wouldn't have given it to me.
but the people that work for you,
Who's that?
you are responsible because
No, which people work for me?
the detective.
No, they don't work for me.
Well, based on y'all behavior at trial, y'all are working together.
No, sir. That's not, they're the,
Based on y'all behavior. Another candidate for both conjugation camp and schoolhouse rock, not understanding the separation of powers, or frankly, anything.
executive branch of government. I'm in the judicial branch of government. We're divided, but we're both at trial. We both attend the trial. They're necessary
Judge,
people.
for the record, I will double check to see if the phone is in our custody. If it is, I'll see.
It was presented. It was admitted into evidence.
Oh, it's in evidence? Well, how was it destroyed?
And I presented it to the jury and showed them how it was destroyed. It was smashed up. The officer
Oh, it was
testified-
smashed before you
Okay,
put it into
I don't
evidence.
know how that happened, Judge.
the officer testified that it was working when he took it from me. The day he pulled me over. I've been arrested.
I don't remember that. Yeah, I'm not doubting. I just don't remember that. I don't call it. You can follow it.
So 19, hold on,
I'm not following. This is a
19.
verbal motion.
19-33629 is the case we're going to try.
Yes, sir.
All right.
And also, I would like to also move to remedy
Yes, sir.
wise. I also would like to move the court based on double jeopardy, collateral estoppel, to dismiss the charges also, and the fact that on the aggravated assault against.
All right. I'm going to give credit where credit's due. He did spit out double jeopardy and collateral estoppel in a reasonable manner. I will say it.
The public servant, that man report admits that I didn't stab him, but yet Mike Laird indicted me. His
No.
prosecutor indicted me for
He didn't
aggravated
indict.
assault against a public servant
He
for
didn't.
stabbing him. When the man report himself admits that I didn't stab.
Credit rejected.
Well, number one, he doesn't do the indicting. The
Well, his
grand jury
prosecutor-
indicts. Yeah.
prosecutor, right?
And the grand jury makes independent findings, but that's not the case we're trying next.
But
Well, I don't expect comprehension. I mean, pronunciation is beyond my expectations.
again,
Take it one at a time.
I'm just
Okay.
exhausted my remedies.
Okay,
You know,
I got you. It's in
for the 100th time.
It's
That's
in-
all. I mean, y'all brought me to court. I might live.
Yes, sir. Go
And
ahead.
just for the record, I'm just making sure that I give Mr. Peoples state's notice of intent to use evidence of prior convictions, extraneous offenses pursuant to 404B and 3707 or 609.
Legal convictions that you conspired against me and set. Well,
that's-
This in the debate time.
I'm giving you, I'm also giving copies of the offense reports and material that came with the escape and the assault on the public servant. He's already got them, but I want to make sure he has the rest of it.
Yeah, the one that y'all had intercepted while I was.
All right.
So I'm
Anything else
giving
you
him
want to
copies.
give to
No,
him?
sir. That's it.
Okay.
So
It's, if there's.
You have all your sexual assault stuff. This is just the extraneous stuff that I plan on using.
oh, the stuff that y'all.
Yeah, the escape and the assault on the public servant.
And then I also was never arraigned for the escape. Why was that? Why was I never arraigned? Why was there a complaint never made? Why was there no charge never made for the
Anything you want to say?
You know,
He's asking you.
it's been indicted and
Okay.
right, illegally indicted because no arraignment, no charge. I didn't find out about that until I came to trial.
Yeah, all right. It's in the record. Your statements are in the record. So if you were convicted, then it's in the record. So you have the right to appeal on that.
Oh my God. Illegally indicted.
What was the point of bringing me here today?
To make sure that the state gives you whatever items. And we always,
gave you that.
we have
So
a
to
review
make
of
sure-
status.
Make
to
sure
make
you know
sure-
what case we're trying.
We always have a review of status when there is a trial pending to make sure that you're ready to go for trial.
Me and y'all both know y'all not about to do that again. Y'all not gonna try that again. So why bring me here playing?
That's all.
20
You're through.
these games?
You're through.
I was gonna be mortified. You're
We're gonna try it. Thank you, Mr. Peebles. All right, what's next?
Samuel Weaver.
Okay. Bye-bye now.
3 KPS Profine. And that's it. Okay, and I've got your jail credit here. Hold on, I thought I totaled all this up. I know I did. I'm gonna do it again. I totaled it up, but I didn't write it down. You owe $425, you get 2 days jail credit, your balance is $125. So tell me why you didn't take care of these tickets.
Because I didn't have a job and I just got one. I start tomorrow at Mendoza Realty.
But here's the deal. When you got out of jail last time, you were supposed to be here the next business day. We show you failed to appear. You didn't even do the first thing that you were supposed to do, which was come to court.
And I ended up having to walk. Like I couldn't even get a ride. I walked home from here. Like literally walked home from here. That's a long walk.
The order is that you're supposed to always be here the next business day by 2 p.m., sir. Where do you work?
Mendoza Realty.
And then I think you're the one that reached out to try to talk to the court, and we were like, just pay your ticket. So you could have.
I called up there because I couldn't get a ride. I did call.
Okay. Here, the order is you have to appear within.
I understand.
Okay. So you owe 122. So you're welcome, or excuse me, 125. You're welcome to pay that and get out, or you'll be out tomorrow. Okay. Good luck.
This is 250941 SM, the People versus Jessica Jazerski Glass. Aaron Wagner's not the promotion.
Morning, I'm James Guzek, campaign, Mr. Jazerski. She's had the opportunity to go over vice to vice form. She signed it, had no questions. Could enter her plea guilty of having contact with Mr. Grindel, and then we're asking if we can address the court prior to sentencing.
All right, ma'am, can you tell me your first and last name? Jessica Jazerski. All right, did you go over this probation violation arraignment and advice of rights form?
I did.
Did you understand your rights?
Yes,
And did you sign and date the back of that?
I did.
And you understand, ma'am, that if you enter a plea of guilty, you'll be waiving the hearing rights listed on this form. We're not going to have a hearing. Do you understand that?
Yes,
Okay. And you've had a chance to discuss that with your attorney? Yes.
And you understand there's a allegation you failed to comply with the no contact order. That's a non-technical violation. So I could give you the maximum possible jail time on this offense. Which would be 93 days. Do you understand that?
I understand.
Are you gonna speak up for my court?
I understand.
All right, knowing all of that, ma'am, how do you plead to the allegation you failed to comply with the no contact order?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to plea?
No.
All right, I'll accept the plea. Mr. Gazicki?
I think obviously the court is well aware of this situation and that of the complaining witness in this matter. Mr. Zuski, she's been under doctor's care for many psychological things. And Mr. Verdug's taken advantage. He's had contact with her, and although it's her fault, or she should not be talking to him, she's obviously, he's manipulative, and she falls into the trap every time. There's not much else I can really say, Your Honor. I'm just asking if there's an alternative to 5 days in jail. As I indicated, court's aware of both parties in this case.
I am.
Yeah, and I just wish the court would take that knowledge into consideration.
Ms. Wagaman, anything?
The only thing that I have, Judge, is that I did call Mr. Zierski directly before the last contact reported.
That's what's so infuriating and frustrating about this.
Correct. And then they had a phone conversation discussing the conversation that I had with Jessica to never contact him, hang up if he calls you, do not respond or react to any text messages. And not even 2 hours later, I got word that she talked to him.
Here's the thing, ma'am. Mr. Verdu is going to use the criminal justice system to harass you and to punish you. Yes, you are. Yes, you are. Yes, you are. He's going to, because he's consistently done it. Here's the thing though, you're on probation. You had a court order. And in that order, I said, you can't have contact with him. And I'm going to refresh your memory. Last time we were here, or the time before, when I learned that you had a VOP for contact with him. And then I was given a stack like
You remember that, B?
this of the two of you going back and forth, where he was verbally harassing you, abusing you.
I mean, she's right, but I like when she gets on a roll. It's fun.
I mean, the whole thing was disgusting. The entire thread of messages was disgusting, but you kept taking the bait. When you did that, I had a really long lecture, man.
Behavior in this case is disgusting.
And in that lecture, I told you, I can't make him. There are things you can do, and it looks like you've done it. At this point, I can't make him not contact you, but I can make you not contact him. And what'd you do? He starts using the criminal justice system again. He contacts you all the time, but you respond and you don't do what he wants, and he goes to your PO, right?
Yeah.
So he goes to your PO and provides some evidence that you have had contact with him, right? And then she calls you.
And then he says, "Gotcha, B."
And your PO tells you, do not have contact with him. The judge has ordered that you have no contact. Do you remember
Fell for it again.
that call?
Yes.
And then the first thing you did when you hung up the phone with Miss Wagaman was do the one thing she said not to do that I had previously ordered, previously lectured you on. We'd already been to court once on it. Do not contact this man. And you immediately put a call into him and started talking about your call with Miss Wagaman. And of course, Mr. Verdu got what he wanted because he recorded that call and turned it over to your PO. So not only are you, and listen, I'm not justifying, I think it's clear his behavior in this case, but you are under court order to have no contact. And the one thing, if it would have been this back and forth, we would have looked at it. But when I have a probation officer
call a defendant and say, hey, remember, you can't talk to him, period. And the first thing you do is get off the phone and call him. Where do you think you're going? Where do you think you're going when you outright violate a court order like that? Yeah. That's right. Ding, ding, winner, 5 days jail. That's where you're going. And I hope you learn something from this, because whatever's going on between the two of you is, quite frankly, insane. And if you have any contact with this man, you're out of your mind, because anytime you contact him, he just turns around and tells Aaron and you go to jail. And the only thing I think is going to break this cycle in your mind where you understand what no contact means is if I send you to county. That's it. That's all. That's the only thing that's going to work. Everything else I've tried lecturing you. Aaron's talked to you. I have literally put it in a court order and you violated the order. Not one.
The wheels of justice are going to roll you right into the Wayne County Jail.
Once, but twice, and probably many, many, many more times. So you're going. Okay, you're going to jail. You had a choice, and the fact I have a recorded call, that Miss Wagaman received a recorded call of you calling him right after she told you not to, there's no choice. I have no choice. You're going to jail 5 days, Wayne County Jail. And when you get out, you talk to Aaron and you do not talk to Mr. Verdude, because if you do, next time I'll put you in for 10. And he's going to bait you, and you know it. What's that? We have more problems.
Yeah, it's not.
I don't know why. That was just really fun. That whole thing was enjoyable.
Yeah, Steve, I just told them. Okay. What do we have ready?
A few moments later.
All right, I have Ms. Lopez in here. Okay, this is 252-910 SM, the state of Michigan versus Nicole Lopez.
Morning, Your Honor, James Gazette.
Thank you, Killer Hippo. I don't know why you're thanking me. It was awesome. We all enjoyed it. And that's very generous.
On behalf of Ms. Colpad.
Morning, Governor.
This matter is set for a pretrial where we're discussing a settlement conference, and I'd like to address bond. Bond be set on the 22nd by Judge McNally for $4,000.
All right, okay, so first and foremost, so we'll set a settlement, date for, we'll set a settlement conference, and, do you already have discovery or?
No.
We're still in the process of sending out discovery.
Okay. All right, go ahead on bond.
Yes, Your Honor, I believe Judge McNally on the 22nd set bond at $4,000. I'm asking for a personal bond. Ms. Colfax does not reside in the state of Michigan. She resides in Toledo. She has a full-time job there, and she has 3 children that she takes care of. Obviously, being incarcerated is going to jeopardize her employment. But the fact is that she has no business to be in Taylor now. She does live in Toledo, and I don't think she'll be a threat to either the complainants in this case or even a flight risk.
Your Honor, on behalf of people, I'm going to object on any modification of the bond. The complaining witnesses are here. I did speak to them, one of them being
The president of the courtroom?
Yes. One of them being the father of the children. And she has 10 children in common with, and the other one being his mother, who's 77 years old. She did
received medical attention for the injuries that she received from the incident in question. And they are very close to any modification if they don't feel safe. We do still do exchanges for the children, I believe, every weekend. And they are in fear of physical testing.
History. I mean, it's she's.
But there is a history of violence between with the complaint links here, and that's what they are bringing up.
Boy.
Yeah, anything in response to that? I mean, she's not charged with the 10-year felony. She's charged with 1-year misdemeanor.
I understand.
And if we're setting a court date, how far out am I setting a court date if she's in custody on a misdemeanor charge? And I'm not negating the allegations or minimizing them, but she's in custody on a $4,000 bond. It's not like she's in on $100,000, right?
I understand, Your Honor.
And she's got, from what I see, she's got a traffic warrant. But I mean, the allegations are that she beat up an elderly woman, with all due respect.
And then for the second charge of domestic violence for Jason, she has children.
Grown-ups behave like this. Like these allegations, like I can't imagine like Ms. Kopaz like being a normal adult woman, and the allegation she goes to a parenting time exchange and starts beating up her ex's mother, an elderly woman. I mean, what is going on?
In front of my children at that.
Ms. Kopaz, you're the defendant. I'm talking about you. You. So you're making it worse on yourself that you're assaulting people in front of kids?
No.
Mr. Azicki, tell your client to not talk, please. Ms. Kopaz, do not talk. You are not helping yourself. It's $4,000, 10%.
I think it is. I know it was $4,000 in Florida when I seen that.
It's $4,000, 10% bond. It's $400. I'm not converting that. That's a reasonable bond. That's a low bond. I thought it was a $4,000 cash bond. It's $4,000, 10% bond. I mean, nobody's going to post I'll convert it. Here's the thing. Someone's going to post $400 for her. So then she gets out on $400. The alternative is I can convert it to a personal bond because at some point someone's going to post $400 and I can give her a GPS tether. And if she's on a GPS tether, I can make sure she doesn't come near you, because if she comes near the complainants with the GPS tether on, she's going right back to county. Does that make sense? Right now, the way this bond is set, it's just $400. Anyone can post it for her and she's out. So I'd rather have her had a GPS tether on.
And I would just like to make sure that no contact order is set.
Oh, of course it is. She can't come near them.
And I would just have an object to any notification.
All right, so you don't, okay, no modifications, bond will stay as it is. I'm not gonna keep her in custody. If you're objecting to any modification, I'm not modifying it. I'm fine with that. $4,000, 10% bond, all the no contact provisions stay in place. We'll set a settlement conference. You don't think it's better for your victims for her to have a GPS on? I don't know. All right, I'm done. Mr. Riggins.
Yes, Your Honor. I'm ready on Ms. Niels.
251787 FT, the state of Michigan versus.
Okay, that'd be a no.
Ms. Moore, who's Is it Mr. Farag seated to next to you up there?
Yes, Your Honor.
Yes, sir. Okay, so it looks like he's returned on a number of warrants.
Yes, Your Honor.
All right, I just did one on
And,
this guy. He's a piece of work.
Looks like confirmation, missed a jury trial, and a confirmation, and then another jury trial. So, Mr. Farag, we're going to hear, I'm going to hear from the state as to where we go from here. Then I'll come back and hear from Ms. Moore. And so, did he have an attorney on these ever?
Your Honor, I believe he had been proceeding pro se. Mr. Pazderka was at one time standby counsel for at least one of these.
Okay. So I would guess, well, let me hear from the state, then I'll come back and talk to you there, Ms. Moore. Mr. Holcomb.
Your Honor, on the cause number ending in 593, the state and the defendant went to jury trial on that driving while license suspended third case. Halfway through the trial, the defendant left and the defendant was found guilty in his absence and a no-walk warrant was issued. That's just the story of
That
one
needs
of
to be for sentencing then.
Yes, Your Honor. So the state is ultimately
Actually, before you go, how long ago did that happen? That was not me, I know.
that happened back on believe it was November 21st of 2023.
Okay. So the warrant's been out for coming up on 2 years.
Yeah. Right.
Go ahead.
So, Your Honor, the state is asking for the court to hold the defendant until a sentencing hearing can be had on this case. The defendant has a very extensive warrant history, and given that the defendant left halfway through a trial and never came back, resulting in a no-walk warrant, the state has serious concerns that if the defendant is released prior to sentencing, that the defendant is not going to return again.
Have you ever had a failure to appear?
Apart from being taken up on another warrant. I would also point out that the defendant has 2 outstanding warrants, both out of Lewis County, that were issued all the way back in 2022. So this is a defendant who has a long history of warrants and of ignoring the criminal justice process until compelled to appear following being held on a warrant.
Ms. Moore.
Your Honor, defense's request would be for Mr. Farag to be released on his own recognizance on the pending matters, given that they are D3 charges, and for the court to, if not willing to PR him on the post-conviction matter, to set bail no more than $1,500. Mr. Farag is, I believe he would struggle to pay any amount of bail, and I would ask the court to give him the opportunity to handle these matters out of custody one last time.
So is he seeking court-appointed counsel at any point? Do we reappoint Thurston County Public Defense for the purpose of standby?
I don't believe I believe he's seeking to continue pro se, Your Honor. I guess I'll defer to the court on whether the court feels the need to reappoint standby counsel.
All right. Well, I know that he's proceeded pro se quite frequently in the past. So what I'm going to do here for today on the post-disposition case where he was found guilty by jury trial almost 2 years ago, he's going to be held on that case. Commissioner Wool was the trial court officiant judge there. And he's on the in-custody calendar the day after tomorrow. So we'll just set for sentencing the day after tomorrow. And then on the other cases, it'll be $1,000 cash or bond in each case. All that can be dealt with again tomorrow following the sentencing hearing.
Judge, can I say something? Judge Myers?
Yes.
Proceed pro se. See, I went through the pretrial proceedings and the pretrial hearings, and we had bail posted in light of the Lewis County case, which hinges on Thurston County. adjudicating this third degree suspended, because that third degree suspended hinges on the third degree suspended in Thurston County, the originating jurisdiction. I want to prepare for that sentencing hearing that you're going to hold me on for a day or two more with Judge Wool as the trial judge. I've got serious matters out there. Things are falling apart out there. I got 2 dogs, purebred German Shepherds, worth thousands of dollars and time and money invested in them for the last 4 years that I've had since they were puppies, 2 sisters, 8 weeks old. And my car is out at Park and Ride in the Kent Des Moines Road. I can't seem to get that secured and returned to Olympia. And I've already done 5 days jail. I want credit for jail time served, Judge.
Okay.
Going back
Well,
to
see,
day one.
okay, hang on just a second there, Mr. Frag. I'm going to stop you there. You know, the trial judge is the one who needs to sentence you, and that's
Right.
Commissioner Wall.
All I'm asking, Judge, is to give me some time out of custody to present my sentencing motions and assignment of errors and extenuating, mitigating circumstances. It's a complicated thing. Everything hereafter is going to hinge on this sentencing hearing. And it has to go before Judge Wool, the trial judge, and I understand that. But I'm saying I've proceeded in good faith previously when bail was posted in an identical situation as this. All through the pretrial hearings, before you, before Buckley, before Pro Tem, the motion hearing didn't come through. And then I went through the trial in good faith. But it's the first trial, Judge, the first trial ever on a third degree suspended sentence. You know, I would have been assisting the prosecution to convict me, the right to confrontation, the cause of the stop with the state patrol trooper. I couldn't question him, and I didn't have that opportunity previously. I'm just saying I've got a lot at stake out there. My security of my house, the security of my car, the contents. I've got legal matters on 2 devices in the car that if it got broken into at that Park and Ride at Kent Des Moines Highway at I-5, or if they stole that car, that's a high-risk theft vehicle. It's a 2012 Honda. And, you know, it's just going to make it impossible on me. And I'm having difficulty getting somebody to rely on out there, let alone to post bail. I mean, I've got money right now, Judge. I can post, if they don't tie up my money on a card, to post $1,500 with more. I promise to appear to post more bail, but I got to untie my hands, Judge. I'm going to appear. We're going to resolve this thing. It has to be done sooner or later, one way or the other. We have to resolve these matters. I'm just saying, let's proceed from here on with these pre-trial hearings and the sentencing in an orderly manner. I can't present all my arguments and start listing there. I got a stubby little pencil. I can't get paper. In the jail, I'm restricted, you know, beyond reason. I'm just saying, Judge, why don't you give me a break? They stopped me for a bogus, phony reason. It was bumper-to-bumper traffic going back 10 miles before Fife up at 272nd. And I'm trying to ease the traffic and going around a car on-ramp at 272nd, and there happened to be a police right there that I couldn't see beforehand. And there was no danger to any motorist. I was trying to ease the motorist. And then
Okay, so, Mr.
Give me a break, Judge.
You know,
I've been.
Here's my issue with why I'm doing what I'm doing. Okay, and give me a minute. I let you speak for a while, so let me speak for just a minute. And that is, you know, you had a trial, like we haven't seen you for 2 years. And so,
Judge, I haven't been in trouble in that 2 years.
Well, that's good, but
yeah, see,
that's not entirely true. You got negligent driving in King County and some other things in 2024. And so you're going to have to, I'm just telling you, you're just going to have to wait for 48 hours here until, Commissioner Wool's on the calendar and this case will be heard. With regard to your assignments of error and your appellate issues, that can all comes after sentencing. You'll have plenty of time to get that stuff together. But given the amount of time you've been gone, and then frankly, in the manner in which you left, when you left in the middle of proceeding, and then we didn't see you for 2 years, I'm concerned that if I do let you out, we're not going to see you again for another 2 years. And so
No, I can't
you're
live,
just going to,
Judge. I
you'll
can't
get there,
live
you'll
with
be
the warrants
sentenced on
hanging over my
Thursday
head.
afternoon.
That's why I'm trying to tell you, Judge, I can't continue to live with these warrants hanging over my head. So now is the time. We have
Right.
an opportunity.
And
right
now's
now
the
to
time we're
see-
taking care of these 4, and then you'll have more after Thursday. You'll
Yeah,
have the opportunity to deal with them in Lewis County.
Going on a week now, Judge. I have things out there that I have to do myself. I have my
Okay.
precious, valuable dogs, and I have my car, my only car. The other 2 cars were damaged by criminals. And
Are you saying, if you've been in custody for a week, did you get transported down here?
yeah, sir, I've been in custody now up until this hearing before you for 5 days.
Okay, so it's going to have to be another 2. Then your next court date will be Thursday at 1:30. And I've tried to explain to you why I'm doing this. I don't know how I can make that any more clear.
Well, you're not cutting me any slack, Judge. We've been seeing each other for a long time, and I'm part of the family. And my personal life and my security, my home, I could end up being homeless over this situation. I could become. I have to have a car to get supplies for the dog. I was trying to do laundry for the dogs when I got taken in, bringing me here in front of you. And I'm talking about 12, at least a dozen or more bath size white towels that I have to clean, do at the laundry, and some soap, a mid-sized box of soap that I can't do without the car. And I have a work exception.
Mr. Farragut, again, I can explain to you again, given the amount of time you've been gone, you left in the middle of a trial. And so you're going to have your sentencing hearing in 2 days from today at 48 hours. And you'll get credit for all the time you've served there. But again, given your
I can't remember, but I think I did this trial.
warrants and warrant history, and there's been a lot. Again, I just don't want to take a chance
Lewis
on letting
County,
you out
that's all
again and
there
then not
been.
seeing you again for, again, a couple of years, which it's been since the last time we've seen you.
Well, the Lewis County hinges on Thurston County, Judge. I mean,
Well, Thurston County will get taken care of in 2 days.
I'm willing to consider the variables involved here. And I think you've made up your mind. You're not considering the hardship on me. The sentence is disproportionate to the offense.
Okay.
The jail time, the prejudice on me, the losses is disproportionate. The right to confrontation. They denied me the right to confrontation. You violated my rights.
That's an issue for a trial on appeal. Like I say, given the record here today, with your absence for an extended period of time, that's what I'm going to do. And we're going to need to conclude the hearing here, Mr. Farag, because I'm not going to change my mind for what I'm doing.
Schedule me for tomorrow.
And I understand you disagree with it. I understand this is frustrating to you, but frankly, it's frustrating for us a little bit when someone leaves in the middle of a trial and then disappears for a couple of years. And so I don't want to take a chance on that happening again. I want this case to close out. And then you can pursue your appeal, all the things that you think you were deprived of at trial.
I can't present the arguments before the judge beforehand, so I have to appeal it afterwards.
Yeah, it is him, isn't it?
And it's
No,
gonna
you'll
put a
get
strain
sentenced on the
appellate
trial,
court.
and then you can present any
Let me look.
argument you want to mitigate sentence. And then if there were errors in the trial, all that's covered on the appeal.
Well, to stay the sentence pending appeal.
You
Now,
can
Judge
you can
Wool-
discuss that with Commissioner Wool on Thursday. He was the trial judge. He'll decide whether or not to stay the sentence.
I understand he's the trial judge, but can you maybe schedule before Judge Wool tomorrow instead of the day after tomorrow?
No, he's not on the calendar tomorrow. He'll be here on Thursday. You're going to have to wait 2 days.
I could
Try me in absentia, and you're not going to prove anything.
That is him.
far longer if he's not available Thursday.
He is available. I've checked the schedule. He's doing the in custodies on Thursday. That's why I'm setting it there.
Well, Judge, I still have objections and issues involved here.
I understand that, and you can
I don't believe that
raise
you're
all
gonna-
those.
I don't believe that you're gonna be any more lenient with me.
Okay. And again, I've told you what I'm going to do. You need.
You jacking me around and railroading me through the trial.
Hearing needs to come to an end, and you can go back and you'll have your next court hearing on Thursday.
And the bail is $1,000
On the ones on the post disposition case, on the conviction, there is no bail on that. You're just going to be held to Thursday.
And the other three charges are
1,000.
1,000 each. So
Yes, sir.
$3,000 total.
Yes, but then you're still going to be held, even if you post that, you're still going to be held on the post conviction matter.
Right, on the one that went through trial.
Right.
Yeah, I understand that, Judge.
Great. Okay, you can be taken back. We'll see you again on
As far as
Thursday.
the delay, me being in custody, and we don't know what Judge Wool's gonna do.
No, we don't. That's true.
I
He does.
could-
I don't
I
even
don't
think he knows you're on this calendar.
I don't know if you even set bail on that Judge Wool matter, if that would assure that I appear for sentencing. Can you set bail on that?
I can, but I'm going to choose, in this case, I'm choosing not to, given the amount of time you've been gone.
Well, I needed extension of time, and I just couldn't get around to it.
You can address all that on Commissioner Wool when he's set to sentence you on Thursday. You can address all that with him.
And you're not gonna set bail.
No.
No, I'm
You can
not.
leave it all to Judge Wool.
Yep. You can be taken, you need to be taken back there, Mr. Farrig.
Okay, Judge. Thanks for your time.
You're welcome.
And I hope we can resolve this in an
Thank you,
orderly
Your Honor.
fashion, Judge.
I hope so too.
All these matters.
Okay, yeah, you need to go. I have a case, a Spanish-speaking individual in court, and Ms. Garcia, I
You
think,
gotta
has been
go.
very patient. I would understand if she hasn't been, but we need to take care of that case. So, Ms. Clark, you can call. And then Ms. Moore, who's seated next to you up there.
Your Honor, that is my client on the calendar docket as Mr. John Doe, number 5 on the calendar, Your Honor.
And I can remember his conversation with him, I think it was a week ago. Any information from an evaluation taken place?
It has not, Your Honor. The two matters that or two representations I can make to the court is I had the opportunity to speak with John earlier today, and he was adamant, repeatedly requested that he represent himself pro se as an individual, and I'll let him speak more to that. I do believe, as per Jabs, that was a request he made.
It was.
That arraignment. And so just highlighting that for the court. In relation to the
Go ahead.
value. Oh, yeah. Thank you, Your Honor. In relation to the 1077 assessment,
Type in the words, Doherty.
I do believe that would be appropriate after my
I like my
conversation with him. I've been in communication with the evaluator. I'm going to be with the evaluator on October 8th.
Hang on, you're starting to break up. Can you mute the jail, please? Okay, say that again, Mr. Krzyzewski.
I've been in communication with the evaluator. The intention is for me to be there and try to effectuate that on October 8th. The evaluator just filed some documentation with the court just like 15-20 minutes ago, Your Honor, noting a good cause extension to try to complete the assessment. And
I have not seen that.
I can forward that to Madam Clerk right now. It's Miss Hamilton, just in case you didn't know. Thank you very much. And I can also provide some information on my client's last name, as he has requested that I inform the court of the last name spelling.
I have it as DOE.
Yes, Your Honor, it's actually Doherty, if I'm saying that correctly. And I can provide the spelling.
Yes, could you please?
Yes, Your Honor, it is D-O-E.
Is it B or D?
D is in dog.
Okay, D, say it again, take it from the top.
Yes, Your Honor, and I will message Madam Clerk actually as well. I just sent that through, Your Honor.
Thank you.
How do we spell the?
I'll message that to you as well, Counsel.
Thank
So
you.
this is just a blank order with no, it says based on good cause for extension, and then there's just a bunch of blank boxes there. Was there a proposed reason why that was a good cause?
There were two documents, Your Honor. One was the blank order, one was a request for good cause extension. And principally that was the evaluator attempted to meet with Mr. Doherty, and that was not successful. I met with Mr. Doherty, and there were some observations where I believed a 1077 assessment was warranted or would be appropriate. And that was the reason we were going to attempt again on October 8th.
So, how do you spell that name again?
It's D as in dog, O as in orange, E as in Edward, H as in Hank, E as in Edward, R as in red, I as in inside, T as in Tom, Y as in yesterday.
All right, give me just a moment.
Is there a date of birth already?
That information I do not have.
Your Honor, I believe Mr. Doherty just tried to provide one.
Okay, well, that last name doesn't pop up. Okay, so Mr. Doherty, I'm going to have you listen to me for a minute.
I'm all ears.
Okay, so I had entered an order to have you evaluated by someone from Western State Hospital. Apparently that wasn't able to take place for reasons I'm not sure why. Hang on, let me finish, please. And so we're gonna reset this hearing till we can do October 10th and give them a chance to get in at least and try and talk to you again. And so I'm gonna leave Mr. Tashevsky as your attorney of record for now. If it comes back that you're competent to stand trial and go forward, then that Mr. Tashevsky can be relieved, and then you can go forward representing yourself. But I'm gonna hold off for a minute until I get some input from Western State. Does that make sense? And I understand you might disagree with that, but that's what we're gonna do here today.
I was listening to one, listening to the other.
I missed that.
I have one reservation.
Go ahead.
If by spilling a hot coffee on yourself, carrying a hot coffee out, 2 cream, 2 sugar, lifting it up by the lid because it was too hot to hold onto my hand, it drops, it burns you. You have a couple of half smokes trying to calm down. And the next thing you know, I'm being arrested for spilling a coffee on me.
Oh.
I don't know about the rest of you, but I'm pretty convinced Rain Man isn't competent.
Okay. So my recollection of what's alleged, okay.
It's not insult to injury enough, having been scalded by the coffee, then being arrested, and now you want a psych evaluation to insult my intelligence even farther, to say I'm stupid because I had an accident. I'm stupid. People have accidents all the time. I don't mean they're stupid.
So again, I'll
No. It's not because of the accident.
I'll try here. You know, my recollection of what's being alleged doesn't have anything to do with coffee. My recollection is that there was an issue about being on the freeway and throwing rocks and so forth. And these are just allegations. It's just one side of the story. I don't know what happened out there, but that's what's being alleged. And so we're going to, again, we'll reset it for October 10th. And then Western State either needs to have a report then, or we're going to go one way or the other there, Mr. Krzyzewski.
Yes, Your Honor. Thank you.
January 11th, 1963.
And that'll be it for today there, Mr. Doherty. Do you prefer to be called Mr. Doe or Mr. Doherty?
Doesn't matter now.
Okay. Okay, Mr. Doherty, you can be taken back. We'll see you
Good
again
point.
on the 10th.
All right. Well, there you have it. That's what I got. I just got all sorts of good stuff. Thank you, everybody, for submitting the clips and for the songs and all that other stuff. Zach and Killer Hippo. Those were both like so fun. Both of those just made me laugh. That was good times. Although it did, I did like 2% of the work. I'm like, I got to go edit a couple clips to give this thing context because I can't do this assuming everybody saw it. But then it was fun. It really was. It really was. Thank y'all for coming out. I appreciate it. I will see you soon.